Ready for dictation, start. The present appeal is vehemently opposed by Dr. Vinod Kumar Tiwari, Learned Counsel, appearing on behalf of the respondents. It is submitted that in the present case, respondent number 2 placed on record voluminous record, namely Exhibit W1 to W6, to show that respondent number 2 was working as a salesman with the appellant. It is submitted that the appellant came out with a false case to get out of the obligation difference in salary to be paid as claimed in the application. It is therefore submitted that when on appreciation of evidence and considering the material available on record, the Labour Court held that respondent number 2 was employed as a salesman and thereafter directed the appellant to pay the difference of wages. It cannot be said that the Labour Court exceeded in its jurisdiction. It is submitted that when on the face of the record available, it was found by the Labour Court that respondent number 2 was in employment of the appellant as a salesman, and in the claim before the Labour Court there was found a difference in the salary pay for the period from 1/4/2006 to 31/3/2012. The Labour Court has not committed any error. The High Court has rightly dismissed the writ petition. We have heard the learned counsel appearing on behalf of the respective parties at length. At the outset, it is required to be noted that respondent number 2 herein filed an application before the Labour Court under section 33(c)(2) of the Industrial Disputes Act, demanding difference of wages from 1/4/2006 to 31/3/2012. It was thus the case on behalf of respondent number 2 that he was working with the appellant as a salesman. However, the appellant had taken a categorical stand that respondent number 2 was never engaged by the appellant. It was specifically the case on behalf of the appellant that respondent number 2 had never worked in the establishment in the post of salesman. Therefore, once there was a serious dispute that respondent number 2 had worked as an employee of the appellant and there was a very serious dispute raised by the appellant that respondent number 2 was not in employment as a salesman as claimed by respondent number 2. Thereafter, it was not open for the labor court to entertain disputed questions and adjudicate upon the employer employee relationship.